Have you ever been in a situation where your employer announces a significant change to your job duties, your work schedule, or perhaps even your compensation structure, and it feels like it came out of nowhere? It can be unsettling when your workplace seems to be shifting the goalposts without your input, leaving you wondering about your rights and options. Generally speaking, your employer cannot unilaterally change a fundamental term of your employment contract without your agreement. This means that for significant changes to your job role, pay, hours, or other core conditions outlined in your contract, your employer usually needs to obtain your explicit consent. The reason for this lies in the basic principles of contract law. An employment contract, whether written or implied, is a legally binding agreement between you and your employer. For a contract to be altered, both parties must agree to the changes. If an employer attempts to impose a major change without your consent, it could be considered a breach of contract, or in some cases, a constructive dismissal, meaning the employer has fundamentally changed your job to such an extent that it amounts to ending your original employment. If your employer proposes changes, it is important to understand them thoroughly. Ask for clarity on what is being altered and how it might affect your role and compensation. You have the right to review these proposed changes and seek advice. If you do not agree with the changes, you can express your concerns and attempt to negotiate. Documenting all communications regarding these changes is a very wise step. It is also important to consider your specific employment type. For example, if you are an at-will employee, the rules can be a bit more flexible for the employer. At-will employment generally means that either you or your employer can terminate the employment relationship at any time, for any non-discriminatory reason, and without notice. However, even in at-will situations, employers still cannot make changes that violate anti-discrimination laws, public policy, or implied contracts, such as those created by employee handbooks or consistent practices. Understanding that your employment contract is a two-way street is powerful. It empowers you to engage in informed discussions with your employer about your working conditions. By knowing your rights, you can approach any proposed changes with confidence, ensuring your professional interests and well-being are respected and protected.